chain in Ghana, which is quite a tongue twister, and participated in qualitative research on customary land tenure systems in Liberia. Kaiser Hughes was awarded a Fulbright Fellowship to Kyrgyzstan, where she researched women's customary land and natural resource rights. She also served as a Peace Corps volunteer in Kyrgyzstan, which means that we're a very good company because a lot of our students at Corbell have also served in the Peace Corps. So I'd like to welcome our panelists. Thank you for coming. The format for today is that our panelists are each going to speak for 20 minutes, and then we will open it up to Q&A to the audience, to all of you. So, Johanna, I'd just like to give a welcome to Ailey Kaiser Hughes first, if that's correct. So, all right, welcome. Thank you.
Gather all of my names. Greetings, everybody. Thank you so much for coming this evening. It's a real pleasure for me to be here and to talk on this issue, which I really care a lot about. And I think Oliver, right? Gave a great introduction, and I agree. Land, can seem boring from the outside, but it is a fascinating issue. And the way we joke about it in a really snooty manner, I guess, thinking about it now at Landesa, is that anyone can dig a well, but not everybody can work in land tenure. It is so complex and so interesting. No offense to people that dig wells, also really important work. And I also want to say from the outset that it's a little bit embarrassing to hear your own bio. And I was a failed Peace Corps volunteer to Kyrgyzstan. I left after about 6 months. So I'm happy to talk about that experience with you all after the panel as well.
But you went back as a Fulbright.
But I went back as a Fulbright, right. So I'm Ailey. I work at Landesa. Landesa is an international nonprofit focused on securing land rights for the world's poorest people. We're based in Seattle, Washington, but we have programs in China, in India, and in several countries within sub-Saharan Africa. And today I'm going to be talking about the importance of customary land tenure. And this is something that I focus on a lot in my work in sub-Saharan Africa, and that is of real importance to the work that we do at Landesa. So I hope that you'll find it interesting as well. There will be some kind of frameworky stuff, and I'll have to speed through some of the end pieces because I prepared a much longer presentation, but hopefully the overall thing will be good. So to begin, I'd like to open with a quote from Vital Bombazi of Burundi, the former chair of the UN Expert Mechanism on Indigenous Peoples. And he said, "One of the overriding threats facing indigenous and marginalized peoples in every region of the world is the risk of being driven from their land and natural resources, which are vital for their livelihoods, their culture, and often their identity as a people. Key components of this threat include rights to land and natural resources, how people claim their rights, and how they access land. In many cases around the world, governments only recognize rights that are private ownership rights, or what in the US we might think of as fee simple ownership, which is represented with a deed. However, that leaves customary land rights, which in Africa and in parts of Asia, Oceania, the Americas, and the Antarctic, without legitimacy. And it leaves them vulnerable to external threats. So I mentioned the African continent. There, customary land tenure predominates, and it governs approximately 90% of the land. Of the people who access land under customary tenure regimes, only 6% are considered indigenous, according to the African Union. These are primarily hunter-gatherers and pastoralists. That said, all of those in Africa who claim land or who use land under customary tenure systems are indigenous to Africa. In this presentation, I will introduce land tenure and customary land tenure. And I'll skip over the intro to Landesa for the sake of time, and try to spend some time talking about different customary tenure systems and approaches to protecting rural rights in Liberia and Rwanda. Two very different approaches. So to be clear from the start, I am not an expert on indigenous rights, and I don't even really consider, I'm not even an expert on land tenure. I'm constantly learning, and so I think, maybe when I'm 50, maybe 60, I'll be able to call myself a land tenure expert. I do, however, focus on customary rights and other related issues, and within this umbrella term of customary rights, indigenous land rights and indigenous systems have a place. So I think that we can think about customary tenure and extract lessons learned and approaches that can be applied to indigenous land tenure systems. But we also need to be aware that indigenous communities and indigenous systems have their own challenges and opportunities that require their own special focus. So I'll present today on customary tenure broadly, not specific to indigenous rights. And I hope that during the question and answer period, and perhaps after the panel, if you're interested, we can collectively bridge the gap between customary tenure and indigenous tenure systems. So what is land tenure? Is that a clicker for me? Yeah, that'll be good. I don't have to. Excuse me just one moment. So how's my volume? Good? And my pace? Okay, not too fast? Okay, my dad always tells me I talk too fast. Okay. So land tenure is the relationship among people as individuals or groups with respect to land and natural resources such as water and forests, even oceans. This can be legal, which is what we call statutory tenure, or it can be customary, which is what we call customary tenure. And there are several categories of land tenure, and to describe the first, I'll frame it with an example. So in the neighborhood that I grew up in, outside of Seattle, each family, or rather individuals within each family, have ownership rights to their house and garden. This is what we call a private right, and this is something that I'm sure we're all familiar with in the US. Private rights are really, really common here. In contrast, in rural Kyrgyzstan, all community members have the right to graze their livestock on community pasture, but outsiders don't. And this is what is called a communal right. Other categories include open access, such as you might find on the open ocean. So anybody can take fish from the open ocean. There are no parameters really drawn around that. And the final one is the state. So national parks, reserves, conservation areas, schools, public buildings, etc. Land tenure systems are comprised of rules invented by societies to regulate behavior. And these rules of tenure define how rights to land are allocated within communities, who has rights to use, control, and transfer land, and the responsibilities and restraints associated with those rights. So, thinking back to this neighborhood, this suburban sprawl in Sammamish, who decides who gets to live in number 3847, 203rd Avenue Northeast? The person that lives there, what rights do they have? Do they get to decide how often they mow their lawn? Do they get to decide what they plant in their front garden? I mean, here, yes, because they have a private ownership right. They can decide all of those things. Can they decide to sell or rent out their property? And again, the answer is, in this case, yes. And the responsibilities and restraints associated with this. So my parents, they could sell their house, they could lease it out, they can mow the lawn, they can tear up the grass and plant like a rain garden or something. But one thing that they cannot do is paint their house flamingo pink. And the reason that they cannot do that is because the HOA says that they can't. So that is a restraint associated with their right. So in simple terms, land tenure systems determine who can use what resources, for how long, and under what conditions. Customary tenure systems are alternatively called indigenous tenure systems, but for clarity, In this presentation today, I'll talk about, I'll refer to them as customary tenure. Customary land tenure comprises laws, rules, and norms that govern the right of a collective to land and natural resources that do not originate from the state, but arise instead from shared identities such as kinship, lineage, religion, ancestry, and residence. Often, these rules emerge from long-held traditions or customs that are associated with these shared identities. And in many parts of the world, like I mentioned in my intro, customary tenure systems continue to enjoy really strong social legitimacy, especially in rural areas. So just to give an example, I worked briefly in rural Ghana, and there you find the reach of the state, when you get into remote rural areas, the reach of the state is quite weak. And customary tenure systems, I won't say they fill the void because they precede the state. But the customary systems are what people rely on when they say, like, where am I going to access my land? How am I going to find a piece of land on which to grow trees for mangoes that I can sell? How am I going to find a place to build my house? I have a dispute with my neighbor. Where am I going to go? The customary system fulfills these needs. So in many customary systems, rights to land evolve according to tradition and land use patterns. And oftentimes they're derived through generations to the original settler. So this is not always true. Oftentimes this is true, especially in the African context. So an example from Liberia, when we did field work there, part of what we wanted to know was how people were able to claim their right to the land. Like, through what was the foundation of their right? And so, many people said I inherited the right from my father or my mother, or I asked the chief and he allocated me this parcel of land. But going back generations, the original right stemmed from one of the original settlers who was the first to clear the trees in the forest and to pull up the logs and to till the earth. And that was how, that is from whence comes the original claim. So some common characteristics of customary tenure systems. This is interesting because customary tenure systems are as varied as thousands, millions of communities that use them around the world. But there are some overarching characteristics. And these really stem from, the foundational piece of this is the underlying collective right to the resource. So the community's right to the land and the forest and the water within their area. Laid on top of that, there are overlapping, multiple, and separable rights. And a good example, I think, is a forest. So again, to harken back to rural Liberia. So within the bounds of the community, there might be a communal forest. And nobody within the community can sell that forest or lease out that forest because everybody owns the community, or everybody owns the forest. There might even be restrictions on how they can use the forest. For example, they might not be able to chop down trees. But they still have access rights. So women might be able to go into the forest and harvest barks or herbs or flowers or edible fruits. Men can tap palm trees for palm wine. They can hunt. Everybody can gather. They can gather fallen logs or tree branches or fodder for their animals. So you see that there are these overlapping, interlinked rights, but they're all based on this communal right, this communal ownership of the forest. Another important point here is that customary tenure is constantly evolving. It's not static. It's not a snapshot from 1500. Like, this is how people lived in 1500 and these were their rules. No, it's always responding to the issues and needs of the time. So why is customary tenure important? Well, It predominates in many African countries. It determines how land and natural resources are accessed, used, and transferred, and this is also true for parts of Asia, the Americas, and Oceania. But despite all of this, many governments do not recognize customary rights to land, and in combination with population growth, with climate change, as Alice was talking about earlier today, this has led to intense pressure on rural communities. And the pressures are diverse. So some examples are pressure from companies and investors that are seeking large tracts of land for agribusiness or extractive industries or other investments. Governments who seek to expropriate land for infrastructure or national parks or reserves. Urban elites who purchase land as an investment opportunity. Communities who take advantage of the governance vacuum to try to steal land from one another. And then even within communities, again, taking advantage of the governance vacuum to try to steal land from your neighbor. Because your piece is it's producing less, maybe it's getting smaller, you're hungry, you need more money, everyone's just trying to survive. So, I was going to talk a little bit about Landesa and how we work with customary systems, but I'm going to skip over this and just say that we recognize the critical importance of customary tenure systems to the livelihood, social structure, culture, and even spiritual well-being of rural communities on the African continent. And I thought, again, Alice put it really well in her presentation this afternoon when she said, people's identity is in the land. Your history is in the land. Your culture is in the land. And I think this is even true. This is even true for us. This isn't something that's foreign or exotic. Like when I talk to my grandpa, who's a cattle rancher, you know, he is the land. He is his livelihood. So, moving on. So I want to talk about Liberia and Rwanda. And these are two countries where I have a bit of experience, and two very different countries in terms of their customary tenure systems, in terms of their histories, and in terms of their approach to rural economic development and protecting the rights of rural people, but similar in their past of conflict, unfortunately, and also in their interest in, as I said, rural economic development and protecting people from external pressures. So I want to apologize in advance. I have so many cool pictures from Liberia, but I couldn't access any of them remotely. So you're stuck with the ones I was able to extract from my inbox. They're not that cool. And the other really good ones, I have a colleague who's a professional photographer as well, and so she takes really great pictures, and I took them all for this. Okay, so Liberia, how many of you are familiar with Liberia? Anyone else? So Liberia was colonized by freed American slaves in the 1800s, and they came to be known as the Americo-Liberians, and they established a system of government and a system of land tenure that really reflected what they had known in the United States, but was very much at odds with the customs and practices in Liberia. So they adopted a legal framework that regarded customary tenure and customary claims as invalid. And people who claimed their rights under customary tenure systems were regarded as squatters on public land. So in short, all land that was not held under deed, which is, I think, something like, even today, 85% of land in Liberia, was considered public land and was available to the government for its, to dispose of as it wished. And the people that lived on it were squatters, though they had lived there for generations, hundreds of years, maybe even thousands. So through this system, the Americo-Liberians subjugated and even enslaved the 16 indigenous ethnic groups that had preceded them in Liberia. This really broken system, along with harsh poverty and the power asymmetry fed into the two civil wars for which Liberia is unfortunately infamous. Those ended in the early 2000s, but the conflict over resources in Liberia continues, but it wears a very different face. And that looks today like governments, companies, and investors and communities facing off to determine who owns the land, whose rights to land are the most important, who gets to decide how the land is used. This is a rubber plantation. Rubber is really common in Liberia, and in fact, one of the biggest concessions is owned by Firestone, and they purchased, or they leased the land for really, it's like something nominal, like $2,000 in the 1960s or 1970s, and they have a 100-year use right to the land. So that's kind of crazy. So after peace was declared, the government recognized the link between land and conflict and economic development, and they wanted to initiate reforms, but there were a lot of challenges persisted. It's a really difficult context. So long history of displacement and resettlement, a breakdown of customary systems because of the many years of conflict. So customary authorities were no longer viewed with respect from many within the community. The customary rules, people thought they were outdated, they weren't adapting quick enough. There were inter-community disputes, so neighbors fighting neighbors, inter-community disputes, clans fighting clans, and then to top it all off, malfeasance on the part of customary authorities, so town chiefs, clan chiefs, paramount chiefs, who would sell off community land without consulting their community members to line their own pockets. Oh man, I've only got 5 minutes left. You're like, yes. So to get to the bottom of these issues, who owns the land? We partnered with the government to undertake a intensive qualitative field research using rapid rural appraisal methodology, which I won't go into here, but I'm happy to talk to you about it later. To try to understand communities, the rights and rules that they have governing land and natural resource tenure, but also their preferences and their recommendations. And from that field research, we filtered that back up to the policy level and made recommendations to the government of Liberia on how they could best protect community lands in a way that the communities would find valid. So these recommendations included, first of all, recognizing community rights as legitimate, so doing away with this idea that undeeded land is public land. Also, creating tenure shells around communities. And to describe that to you, I'll say, like, I mentioned my grandfather in Texas, and he's a cattle rancher. And if you look at his land on a cadastral map, you can see very clear boundaries around his land. And you can say, within this land, Sidney Kaiser has the primary right. This is Sidney Kaiser's land. So when we're talking about creating tenure shells around communities, we're doing something very similar. Finding the boundary with communities in collaboration with them and their neighbors, and then saying this community has the right to this land. But within that, helping them to create bylaws so that they can determine for themselves how they want to manage their land as a community, and who has the rights to land within that community. So that's a tenure shell in brief. So this was adopted into the Liberian land policy and then incorporated into the land bill, which is under debate right now in the Liberian parliament. So the widespread impact of these proposed reforms has yet to be seen. But some key takeaways from this, I think, are that, first of all, engaging with the communities at the research stage really helps to build recommendations that are responsive to the needs of and legitimate for communities. And then my other major takeaway was that getting government buy-in to protect customary lands is a major challenge, especially where powerful interests want to keep doing what they've been doing for the past 100 years. So I'll skip Rwanda, or Rwanda. just like a picture slideshow. Admire the photos of my colleague. You know, I'll just leave it on this slide. So then, just to conclude, I want to reiterate the importance of customary tenure. And customary tenure is important because it is the primary means through which people access, use, and transfer land on most of the African continent and in parts of Oceania, Asia, and the Americas. And it has incredible social legitimacy, especially in rural areas. And until we can really protect customary rights, these people's rights and their livelihoods will be at risk from these external threats. And it's not just their livelihoods. It's also, as I think Oliver covered really well in his intro, it's culture, it's social systems, and it's spiritual well-being. It's so much deeper than just livelihood. So to close, I want to leave you with a question prompt to think about. And this is also something for me, but so based on this intro to customary tenure and the different challenges and approaches and what we saw in the work in Liberia, do you think that this framework can be applied to indigenous land rights? And if so, what are the particular challenges and opportunities in doing that? And what are particular ways that we can assist indigenous communities in protecting their own rights? So, thank you.
Thank you, Ailey. We're going to have to ask you about Rwanda in the Q&A.
I have to ask you about Rwanda later?
Yeah. Now we'll turn it over to Joe, Bryan, for his remarks.
Okay, well, first of all, thanks for inviting me down from Boulder. It's amazing how we don't move around on the front range that much. It's to our own detriment. We should do more of it. But I also really welcome the opportunity to talk about this issue. I think that Ailey's done a really nice job of giving you some of the sort of policy framework around customary rights. And what I want to do for you now is actually outline one of its primary contemporary applications, which has been in Latin America. And the cases that I'm going to describe here in Latin America have really been actually used quite widely as a model for customary use and occupancy, recognizing it as a basis for property in Africa and Southeast Asia, South Asia. I was recently at a conference in Indonesia a couple of years ago where everybody from South Asia and Southeast Asia was totally on board with it, except for the Chinese who said, customary property, we did this a long time ago. Nobody cares about that anymore. It's all private property now. Which actually is quite revealing because a lot of the stuff that I'm going to talk about and that Ailey's talked about is something new, actually comes up if you get into the history of this over and over again. There are sort of cyclical periods where this emphasis on customary rights becomes very important. I'm not going to be able to see my notes because of some communication with this, but I've done this enough so that hopefully I can do it. So in Latin America right now, the entire region is in the midst of what's oftentimes referred to as a territorial turn in approaches to governance. And this broadly construed refers to the transfer of control over lands previously owned by the state. So in the US, we would call these public lands to various forms of communal tenure. Most of this has been to indigenous peoples living in forested areas, although a lot of these issues have now been used to extend territorial or property rights to Afro-descendant communities and other traditional communities. And so this gets very interesting from my perspective, because I like complicated things. Once you get into areas around the edges of the Caribbean, also in the Brazilian Amazon, and in Colombia as well, where you have a whole variety of people who've never been considered indigenous in the past now actually getting these same kinds of rights. The changes have been massive. Somewhere around 200 million hectares of land have been transferred in this territorial term. That's an area larger than the country of Bolivia in this area. And here's a map that gives you, it's not totally up to date, but every one of these red blotches on here represents one of these sort of indigenous owned territories now. Sometimes they're recognized as territories, sometimes as reserves, sometimes as property, but they all sort of have this basis in recognizing customary use and occupancy as the basis for establishing control over land and resources. Every one of the red blotches on here has a detailed and torturous history behind how it came to be, which is what a lot of my research has looked at. How did this little area here in the Bolivian Altiplano, I see, it bounces my laser back at me. How did this area in the Bolivian Altiplano, for example, come to be titled to the communities that are living there? These are the kinds of things that geographers like myself have spent a lot of time looking at in recent years. And so there's three axes of this territorial turn in Latin America. The first, and this is really how I got my start in this topic, is that social movements from around the region, primarily indigenous movements, but also Afro-descendant movements as well, have been making these demands for territory now for well on to sort of 3 decades at this point. And every time, this has been oftentimes about gaining control over land and resources that they effectively use and occupy now, but are threatened oftentimes with dispossession by oil companies, logging companies, agribusiness companies, even just the states are taking away land from them. And this has been the impetus for a lot of these social movements. In this same period, though, there's also been an important set of legal transformations at the international and at the national level, and I'm sure that some of you have studied these, that have increasingly recognized rights to territory as a human right? And this is a key piece of things like the International Labor Organization's Convention 169, the UN Declaration on the Rights of Indigenous Peoples, and so on and so forth. The third piece of this has been the discovery, or I should say rediscovery, of customary tenure by macroeconomic theorists, particularly at the World Bank, who have looked at these as the solution to solving not only resource conflicts in historically frontier regions of Latin America, but also to establishing state control or state authority in areas that have oftentimes been places where the state has had very weak control or weak presence. So we're talking about, the sort of forested areas of the Amazon basin, but also I'll show you here places in Eastern Central America where I've been working for quite some time. Also places that are sort of tucked away, like in the mountains of southern Mexico, also in the Andes in South America. And what's interesting about this is that this territorial turn doesn't just simply go out and recognize community property systems that are already there and draw lines around them and say, okay, we've gone out and basically done the 19th century thing, drawn a map that shows this is where these people live and now legally recognize it. They actually create these property systems, right? And this involves modifying customary use and occupancy and transforming it into something that can be legally recognized, oftentimes in terms of property. Number of approaches to this, and you can see right here that initially, and I'll walk through this some more. Get used to my clicker now, pointed. property and territory and land were sort of used all interchangeably, oftentimes in English. They actually have very different meanings and different histories behind those meanings that I think are really important to recognize, and I'll walk you through those here with these next couple of slides. So let's start with indigenous peoples movements in particular. Their demands for territory have oftentimes been based on this idea of historical use and occupancy. That's how you prove to people who are not from your community that you actually live somewhere and that you use the land and resources there. And this is, of course, people living in these places, they know this full well. They interact with each other, they have social systems that allow them to negotiate access to land and resources. It's people coming from outside who don't see these things, and oftentimes deliberately don't see them because they would like to claim things that they see as empty or unoccupied for themselves, that have really sort of been the catalyst for making these demands for territory. How do you make yourself visible when the society around you does not want to see you? This idea of territory then has evolved to become the sort of fundamental space in which indigenous peoples need to exercise a degree of self-determination. And that's the ability to define the membership of your community, to define how you use land and resources, define how you govern yourselves, et cetera, et cetera. And this again borrows from international law, but applies it to sort of a new category of indigenous peoples. And it also is then lastly used as a push against oftentimes state-sanctioned dispossession, right? These kinds of things where the state comes in and says this land is unused or unoccupied, therefore we can claim it for the state. And this goes on not only all over Latin America, but also here in the United States and Canada. It's also baked into our history of public lands here, right? So wilderness areas, for example, have dense histories of human use, oftentimes by native peoples, that we no longer see because we see them as wilderness and as pristine nature. So these have been sort of addressed then in a series of legal reforms. I won't bore you with these details, but those of you who are studying this kind of stuff in your classes, you've probably already seen this, and if you haven't, I'll just draw your attention very quickly to these articles that have defined territory in some very interesting ways. The ILO 169 was the first to do this. The UN Declaration on Indigenous Peoples has adopted some of this language and evolved it somewhat. But the real challenge, as those of you who study international law know, is that the UN, the OAS, Organization of American States, can declare these laws, but turning that into hard law that states respect and that actually guarantees rights is a whole other ball of wax. And to that extent, indigenous peoples in particular have had increasing success going through the Inter-American System of Human Rights, which is organized by the Organization of American States, and is their sort of formal legal body for adjudicating cases. And I'm going to talk in particular about the first case that went through this Inter-American system, all the way to the Inter-American Court, that resulted in formal legal recognition of customary use and occupancy as the basis for rights to property. And that case was brought by a small community in eastern Nicaragua known as Awastingni against the government of Nicaragua. It started in 1995. It was ruled on finally in 2001, just days before September 11. So what should have been heralded as this sort of precedent-setting legal event was quickly buried amidst other more pressing news. Many of you who've studied indigenous rights probably have also learned about this case because the community's lawyer and the real sort of brains behind this case was S. James Anaya. Jim Anaya is a professor of law at University of Arizona, but he's also most recently been the UN Special Rapporteur on Indigenous Rights. And that's sort of the UN Special Investigator on these kinds of things. That case has also then converged with a series of constitutional reforms that come out of a very different set of sort of backgrounds that recognize collective rights to property. Nicaragua in 1987, Brazil in 88, Colombia in 90, Ecuador and Bolivia have adopted more recently have incorporated into this constitution. There are other countries in Latin America that have done this, but again, these are sort of the big references. And one point that I'll draw your attention to is that two of the most important pieces here. Nicaragua in 1987 and Colombia in 1990. What was going on in Nicaragua in 1987? The Contra War, right? And this was a move by the Sandinistas to try to neutralize or partially meet indigenous demands for territory that had been playing into the hands of the Reagan administration, among others, in the US, who were trying to destabilize Nicaraguan society. In Colombia in 1990, a similar sort of twist. Colombia, as you know, has had a multi-decade civil war. I hesitate to even put a number on how many years it's been going on for, because I know people argue over that. But nonetheless, in 1990, the Colombian government made a concerted effort to bring indigenous armed groups who saw themselves as fighting against both the state and paramilitaries and guerrillas into the fold by giving them some recognition of their land rights. And this actually became really interesting because then it was extended to Afro-descendant peoples. And again, this is a fascinating case for those of you who are interested in these topics. Ecuador and Bolivia, this has been the centerpiece of sort of leftward or left turns in those countries led by the administrations of Rafael Correa in Ecuador and Evo Morales in Bolivia. So then the macroeconomic side of this, though, really comes out of this guy named Hernando de Soto. There are many others, but he's sort of the leading figure to know about in this debate. He's a Peruvian economist, and de Soto was sort of working in Peru at the time that the country was involved in a huge civil war with the Shining Path. And de Soto's sort of big idea was to say, how do we incorporate all these poor people that are the sort of ranks from which the Shining Path draws into society? And his sort of answer to that question was, we go out and formally title the assets that they've created with their sort of sweat and labor, right? So initially this was in slums around Lima, where he said, we're going to give people formal title to houses that they build so that they can have access to credit, and therefore they will be brought into the system. They will have more to gain by being inside of the state apparatus and having legally protected rights granted by the state than being outside of it and joining the Shining Path. And hence the name of his book, The Other Path, which was blurbed by everyone from Bill Clinton to George Bush and Margaret Thatcher as sort of this new approach to solving the problem of poverty and conflict in the developing world. These ideas were enormously popular at the World Bank in the 1990s and really sort of were the impetus for the World Bank's direct involvement in creating laws that recognized customary use and occupancy in Colombia, again in conjunction with that constitutional reform, in Bolivia, well ahead of that constitutional reform, and then in Nicaragua and Honduras, Central America in the early 2000s. That Nicaragua date came as a means of the World Bank sort of getting on board to try to make the Awastini case have some teeth to it and get titling rolled forward. This has been much critiqued. I won't go into the details of this, but it's particularly been critiqued by my colleague and sometimes co-researcher, Charlie Hale at the University of Texas, Austin, who's described this moment as kind of one of neoliberal multiculturalism. And what he means by that is simply to say that recognition of cultural-based rights to land, particularly from Afro-descendant and indigenous communities in Central America, has been conditioned upon them dropping their opposition to the underlying economic model that says property is the basis not only for organizing markets, but also for organizing society. And this is a very liberal belief. This goes back right to Locke, and hence the kind of idea of this being part of the liberal and neoliberal comes in part from this emphasis on property. And the bank, and he was looking particularly at the bank's role in these reforms in Honduras and Nicaragua. So the outcomes of this territorial turn, though, which now, you see a lot of these laws have been in place for a decade, sometimes 2 decades. We can now start to sort of see, well, what's come of these legal changes? What difference has this made in everyday sort of life in some of these areas? And one thing that we can see is definitely there's been a lot of legal recognition of these rights, facilitated in part through the kind of participatory mapping work that I do, where you go out to the community and help them make a map that literally shows the location, extent, and organization of their customary use and occupancy, so that a state official can see it and use it as the basis for formally recognizing those rights. Where it's really lagged, though, is states have been increasingly inclined to recognize those rights, but the lag has come with security of tenure. You have the piece of paper that says you own it, but you don't necessarily have effective control of it, right? Possession is 9/10 of the law. You can read that incredible chapter in Moby Dick on fast fish and loose fish, where he talks about property and gives a sort of allegory of colonialism that fits this situation very nicely. The other key thing that we don't know much about, or we're still struggling to understand, is that part of the rationale for this territorial turn has been that it would improve resource governance, particularly in forested areas, so that you would not be cutting down forests, you'd actually be conserving them. That hasn't necessarily happened, and I'll show you some of the reasons why. So let's now skip to some cases. So this is northeastern Nicaragua, where I do most of my research. These, you take my word for it, these sort of pastel Easter egg colored blobs are all territories now that have been titled to blocks of communities in this region. And the key one here has been Awastingni that really got this whole process started in the mid-90s. Almost every community in this region was either evacuated or severely destroyed during the Contra War. So coming back after the war, they basically had to rebuild themselves and jumpstart customary use and occupancy in these regions. Awastingni went about doing this by, in part, entering into a sustainable forestry project with the World Wildlife Fund. It was supposed to be a model for community forestry in this region and was tied into resettlement, post-war resettlement of this region. Awastingni was completely evacuated for almost a decade during the Contra War because it was right on the patrol path for mosquito forces and Sandinista forces going back and forth across this area. So with the help of lawyers funded by World Wildlife Fund, Awastingni turned this hand-drawn map that they gave to Jim and Aya when he first went there in 1994 into a GIS-based map that showed where the community was. It also did a rough allocation of their land use and then showed the extent of their community forestry project, and then showed this sort of series of blocks with numbers on it where the state had recently granted exclusive rights to a Korean-financed logging company to log without consulting the community. And Anaya and his colleagues went forward and said this actually violated the Nicaraguan Constitution, that one passed in 1987, and said it also violated the community's human right to property. And they won quite miraculously, really, in some cases. This really caught a lot of people by surprise, even though a lot of the pieces were there. And that's about when I got involved in this case, was in 2002, looking at how we take this legal case and turn it into actual rights on the ground. And so working with Jim and Aya, then I started in this process of sort of figuring out how we were going to settle this. The problem was in Nicaragua was that over the top of this, a whole other mapping exercise had happened, funded by the World Bank, that looked at sort of use and occupancy of land and resources, and produced its own set of maps. And this wouldn't have been that incredibly problematic if it weren't for the fact that one of the things this study found was that all of these areas of use and occupancy overlapped. They didn't have neat boundaries that could be titled as property. They, in fact, were all knit together. And this was an important social feature of customary use and occupancy in this region, is that uses overlap, and they're negotiated socially rather than relying on lines to determine who owns what and where. And Awastingni, by the way, falls right in the middle of sort of in this black circle area there. Here's another map that was produced of Awastingni's claim after the fact, showing the extent of these overlaps in the sort of blue, yellow, and then blue again line areas. And part of what happened then in the case of my research there is that they went from a map like this, to having their GIS map that they went to court with, to suddenly finding themselves in the middle of this tangle of overlapping claims, to eventually actually losing control over a huge piece of their territory because of how the titling and demarcation process played out. That's a long and complicated story, but I want to sort of show you here how customary use and occupancy was the basis for this conversation, but it by no means had the last say. And then back to that earlier map, this area that you see here in red, that's the area where the most deforestation in this region has happened since between 2002 and 2008. And if you are good spatially, that coincides exactly with that overlapping claim area between Awastini and those neighboring communities who are also indigenous. And part of what was going on in this region was that people were going out and logging preemptively. They didn't know whether they would have control of this area next year. So might as well go out and cut that mahogany log now, especially if there's some guy in the main capital city who will loan me all the money I need for gasoline and say, oh, pay me back later when you have the boards ready to deliver. So they got very much mired in this sort of quasi to very illegal logging going on in the region, as did all the other communities around them. There were violent conflicts then also between people, veterans of the Contra War who didn't have land and didn't have a place to go but had been promised land by the government of Nicaragua, who started squatting on these lands as well. And that produced a series of violent conflicts. And then on top of it, you had drug traffickers coming in and using cattle as a means of basically laundering money from cocaine trafficking in the same region. So the lessons from Awastini, ownership doesn't guarantee security of resource. So legal rights on paper doesn't necessarily guarantee effective control. The guarantee of those rights is also ultimately dependent on the state. And this is somewhat ironic because their claim starts by saying the state itself is operating as if we didn't exist and has forcibly dispossessed us or threatened us with dispossession for centuries in some people's cases. And now we're going to turn to them and rely on them to protect our rights to own this area. Essentially protect us from a crime that the state has itself committed, as some of my colleagues in Nicaragua put it. And also property doesn't affect these sort of macroeconomic questions that have people logging illegally or have cocaine going through this region. And it doesn't do much about racial inequality. It gives you ownership, but it doesn't necessarily address some of those structural questions of racism that will allow a state official to say, let the Indians fight it out, they're violent. We'll just sort of wash our hands of this until they've sorted it out. I'll get to quite ugly fast. I was involved then in similar work in Honduras, right across the border from Awastini, where we resolved these sort of stringy maps into a map here, working through a community methodology that I'll describe that produced lines amenable to state recognition, but also maintained these sort of social networks that allowed people to go across these lines at will. And it actually succeeded in getting these communities title. But again, it was immediately torched by the fact that cocaine was going through this region and that traffickers were very much involved in deforestation. And community members themselves were not innocent in this. They were also participating in this. These are some of the poorest areas in Central America, poorest areas in the Americas. Somebody offers you money to move this, that, or the other thing. You oftentimes do it for reasons of like putting a school uniform on your kid or paying a medical bill. I could go through example after example, but sort of the big picture I want you to see is that in other countries where this has happened, protection of indigenous lands, shown here in red in Colombia, has oftentimes gone hand in hand with the allocation of new resource concessions, particularly for oil, gas, and minerals. So those are shown here in yellow in Colombia. And it's oftentimes been one kind of going along with the other. And the idea for states here has been we're going to resolve this whole question of who owns what resources in sort of one fell swoop so we can facilitate the kind of foreign investment that comes along with each of these concessions. Here's Peru. Yellow shows the oil concessions, red are indigenous lands. And here you see actually a different dynamic that's developing, where the state has gone out and entitled lands and then turned around and said, okay, we just gave you, Indian community X, title to your land. Now negotiate with the oil company and you can't say no at this point. And this has been very problematic, but not just in countries that are fully committed to the sort of neoliberal economic free market model, but also in some of the left countries or left-leaning countries in the region. This is the Tipnis area in lowland Bolivia. The communities there have their land rights recognized, and the Evo Morales government has allocated a oil and gas concession north of the community. And then as a part of that, they've agreed to build a road right through the community's lands, even though the community wants nothing to do with that road because they see it as being sort of a highway for illegal loggers and all sorts of other people coming into the community. Ecuador, yes, I'll just finish this up. Ecuador has gone through the same thing with Correa, titling the lands that you see on the right, or on your left, at the same time of allocating virtually all of the Amazon basin in the country to oil concessions. So just very quickly, I think the things that we can see is that community tenure, the sort that Ailey talked about and that we're all interested in, is very important, but property rights alone don't cut it. Particularly because they leave these sort of racial and economic questions lingering, and they don't question the underlying model of what people actually do with their land and resources, and who gets to make those kinds of decisions. And that is sort of the key question that I think I'm certainly addressing as a researcher, but also learning from a lot of the communities where I work about how they're navigating this kind of situation. The critique is good, but the real $50 question is how do we survive this mess that we're in with some hope of being able to create these spaces that will allow for a collective way of life. And this is where my most recent work in Mexico is really in. So thank you.